And so what I'm going to do tonight is spend a few minutes talking about some of the key points in litigation and what's really going on in the mechanics. I ran into a psychologist who was sitting in a corner of a cigar store pontificating that lawyers destroy people's lives through this process. Can't really argue that lawyers don't do all that they can to help people during the terrible time of custody litigation. I learned some key ideas that I want to share with you about some of the biases that people believe about the divorce process and try to help you get a clearer vision of what's really going on behind the scenes during litigation from terms of mechanics and what divorce coaching can do. I think people are going to be much more comfortable with coaching relationships in the future. I don't know if any of you have seen the Best Life magazine, which is, I call the married man over 40s cosmopolitan. But in all the different articles in the Best Life magazine, you have different coaching sections, whether it be the executive coach, I think they call it the career coach, they have the fitness coach. And so I think people all over America in terms of societal trends are going to be more comfortable with the coaching relationship than in the past, certainly more comfortable than they would with a therapeutic role. Also, I see in the future a trend that people trust others that have hyper specialties, and certainly claiming to be a divorce coach on top of providing therapy. I think people will see the benefit of having more than one specialization. I think another trend you're going to see, people are more discriminating in making their choices for mental health professionals or lawyers or any type of service provider. I don't think there's any doubt of that, and they look to the internet to help them make that discriminating choice. I think people know intuitively and expect to feel depression, guilt, fear, and the other common emotions in divorce. They know it's coming, so they're going to look for ways to manage that fear. And finally, if a client's emotional state or a patient's emotional state really starts to take a nosedive and serious problems come up during this coaching process, which I think we've all seen people who go through stressful times and do fine for a while and then fall apart or spiral down. Who better than a mental health professional to identify that situation and to help the person make some corrective changes and or get into therapy? I think that's clear. Now, let's talk about a couple of different divorce situations. What we see most often, take a 19-year marriage, children over 13, both children over 13, maybe one already heading into college. Certainly both are not as emotionally dependent on the parents as they were. The marriage hasn't been there for a while. The parents decide they need to get a divorce. One or both head off to lawyers, and a divorce complaint is filed. At that point, the lawyers go to work. What do the lawyers do? Help the parents put together a parenting plan, which is much more detailed, 17 pages or so. Help them figure out the child support. Help them figure out the property division. What's the pension worth or pensions worth? How do you divide them up? That's becoming a much more expensive process every day. As well as what's the house worth? How do we divide the cash? There's some mechanics there that lawyers have to take some time and do their work on. Let's say in a best case scenario, that's done in 120 days. All right? The non-contested divorce. At the end of the process, divorce settlement paperwork is drafted up, shared with the other lawyer, probably going to be rejected, probably maybe some changes, maybe a few harsh words in the process. Maybe they head off to mediation at that point. They go to mediation, spend a day or so with a top mediator in Memphis. They get the deal done. The divorce is over. 145 days. Maybe a $1.2 million estate. Both parties have, compared to the size of the estate, some decent attorney's fees. But at the end of the day, they realized they worked it out for the benefit of the children and didn't fight needless, meaningless battles. Unfortunately, that's a nice scenario that happens every now and then, but not as often as we'd like. What we're going to talk about is more of the high conflict divorce, what some lawyers call the scorched earth litigation. And this is very, very often, especially the psychologists in this room that have received a phone call from me saying, I need an affidavit. Can you help me out? Of course, the next follow-up question is, when do you need it by? And of course, the answer is, tomorrow morning. Well, I haven't seen your client. Does that really matter? The answer always is, yes, it does matter. If you want something good in the affidavit. I think I want something good in the affidavit. My client's not going to kill the children tomorrow. So, the high conflict divorce is something that we're all aware of. And this is where my favorite pipe-smoking psychologist was discussing with me and how lawyers tend to fan the flame of this litigation. And I had something that I thought in my own mind was very brilliant that I needed to share with this psychologist. Most often we're not fanning the flame of conflict. We have plenty of conflict already existing in our practice. We don't need to invent any more. I'm not sure that that was believed, though. But I'm not here to try to convince you of that. The high conflict divorce, or the scorched earth litigation divorce, has some hallmarks I'll share with you. And you probably already know this already. First, one party or both parties are unwilling to negotiate or even agree on meaningless temporary items while the divorce is pending. For example, if there are already two households, which parent houses the children, the location of the toys, the clothing, the bedrooms. Even if they got two sets of bedroom furniture, there's going to be an argument that all of it needs to stay at one house. We've all seen it. What makes that difficult is the courts don't want to micromanage parents going through this process. A court's not going to decide which t-shirt goes to which house. Just not going to do it. They're much more likely to order us into the hall and ask the good psychologist who may have already been appointed to the case for that psychologist to decide, which is a whole different issue. Another thing, another hallmark of scorched earth litigation is, of course, refusing to provide required documents in discovery. The emails that I guess everybody's now reading back and forth between various parties, and whether or not the email's been intercepted or the result of wiretapping is always an interesting topic. But it's amazing what people put in email in 2006 as opposed to 1997. But not providing the discovery as required by court order is a very common tactic. It's obstructionist, it's difficult, it's painful, it's awful, it's expensive. The goals for individuals involved in scorched earth litigation include vengeance, retribution, and vindication. You'll see a lot of personal attacks between the attorneys. You'll see bad faith negotiating tactics, which I maintain a list of bad faith negotiating tactics to explain to my clients when they run into it. And it's not uncommon in Shelby County, Tennessee, to have people do terrible, terrible things in the negotiation process just to drive the other side crazy. The only defense I have to that is that if I can tell them about it in advance, they can prepare emotionally for this. They say, oh, I told you this was coming. Oh, okay. Well, what do we do about it? The answer is nothing. We respond this way.